Hi, I'm Peter Tragos, host of the Lawyer You Know podcast and YouTube channel. The saying goes, everyone hates lawyers until you need one. Well, I'm here when you need one to answer your questions and give you insight that you didn't know you needed. Welcome back to the Lawyer You Know, and we're continuing to break down this Ronnie O'Neal trial that concluded yesterday with a jury verdict. We're going to jump into that verdict. We're going to react to Ronnie's reaction when hearing what the jury had to say about his case and his defense, where he represented himself and made arguments to the jury himself. He cross-examined his son, who was one of the victims. He cross-examined his son's new father, who was a deputy investigating this case. Okay, so it is a crazy case, unlike anything we'll probably ever see again. And we're breaking down the verdict today, and in most cases, this is where our videos would end. But we've actually talked about, based on the live videos and some of the other comments that we've had on videos, everybody wants to talk about this death penalty phase. This is the guilt phase, and the judge has mentioned after the verdict that this is where it becomes even more serious. So if you want me to bring my dad on, who is the king criminal defense lawyer in our state and probably in our country, he's handled death penalty cases on both sides as a prosecutor and a defense attorney. If you want me to get him on the show, leave the big eye emojis as a comment below, and the more big eye emojis, if we get enough, we'll put in the time and I'll get him on, pull him out of whatever he's doing, and we will do a video on that death penalty phase, what it's going to look like, what normally happens, and what we think is going to happen in Ronnie O'Neal's situation. So that's still to come. But today, we're going to focus on this verdict. We're going to react to the verdict. We're going to watch the video of what the jury actually says, and we're going to see the look on Ronnie's face. But before we get to that, please make sure you like this video, subscribe to our page so you don't miss the lives that are still to come. We're going to do another live on Ronnie O'Neal at some point this week, and we're going to look at some more cases. We're waiting for you guys to tell us what cases you most want to hear about that are in the news right now, and we're going to jump on them, we're going to dig into them, and we're going to react to them as they go along in their process. So make sure you subscribe to our page now. And if you stay till the very end, I will give you what I think is his best chance to appeal this verdict.
All right, very good. Welcome back, members of the jury. Everyone have a seat. Mr. Cromley, it's my understanding the jury's reached a verdict, correct? Yes. Okay, if you hand the verdict form to the bailiff, who will hand it to me. Okay. I'd ask the clerk to please publish the verdict.
Thanks, Judge.
Sorry, I know I'm stopping it already. People hate when I do that. But to sit next to a criminal defendant when their life is on the line and the jury verdict is about to be read and you hear that the jury's coming back because they've reached their verdict, I've talked to some of them. They feel tingling all over their body. They feel like their head could explode. They feel like their heart's going to beat out of their chest. They feel like they could pass out. They feel like oxygen's being cut off from their brain. It's an unexplainable feeling is what a lot of them say, and that's probably what Ronnie's going through right now in this video.
State of Florida versus Ronnie O'Neal III, case number 2018 CF 004019, verdict form, trial division 1. We, the jury, find as follows as the count one of the charge. The defendant is guilty of first-degree murder as charged. The defendant did actually possess and discharge a firearm causing death.
So you may have even missed it the way that the juror read it, the foreman read it so nonchalantly. He said, we find the defendant guilty as charged for first-degree murder. Usually they say on count one, first-degree murder. We, the jury, find the defendant guilty. That's usually how they read it so you don't miss it, but he's going to read all these charges just kind of guilty as charged, which anybody that's been following the case already knew that. Jumping into this video, anybody that already watched my live, we've already kind of discussed that it's going to be guilty on all counts. We'll talk about whether that's surprising. All right, let's hear what they say about count two.
We, the jury, find as follows as the count two of the charge. The defendant is guilty of first-degree murder, premeditated murder, and felony murder. The defendant carried, displayed, used, threatened to use, or attempted to use a weapon. We, the jury, find as follows the count three of the charge. The defendant is guilty of attempted first-degree murder as charged. The defendant carried, displayed, used, threatened to use, or attempted to use a weapon. We, the jury, find as follows the count four of the charge. The defendant is guilty of arson of a dwelling as charged. We, the jury, find as follows: the count 5 of the charge, the defendant is guilty of aggravated child abuse is charged. We, the jury, find as follows: the count 6 of the charge, the defendant is guilty of aggravated child abuse is charged. We, the jury, find as follows: the count 7 of the charge, the defendant is guilty of resisting an officer without violence as charged. So say we all, dated this 21st day of June 2021, foreperson of the jury, Russell Cromley.
All right, does either side wish to have the jury polled? Do you wish to have the jury polled? Does the defendant wish to have the jury polled?
I guess so.
Okay.
So his reaction is stoic. He doesn't look surprised. They literally just went guilty down the line, even all the way down to resisting arrest. They did not try to split this baby, which indicates to me that they did not believe anything he was saying. They didn't buy anything he was selling. They didn't buy the inconsistencies of the son. None of it. I think some people are going to say their mind was made up before they even went back there. They deliberated for 5 hours. And in my live, I asked for comments. And in this video, I'm going to do the same thing. Do you think that's a long time to deliberate? Do you think it was too long? Do you think they should have gone in there and within 1 hour they should have come back with a guilty on all counts verdict? Or do you think 5 hours was too short and they should have taken more time when considering a man's life is on the line and they know the death penalty is the next part of the phase of this trial? Do you think 5 hours was not enough time? So let me know that in the comments what you think, because I'm always interested in what lay people think, because lawyers, we all probably think the same thing about this 5 hour deliberation, but I want to know what you guys think, because you guys are the people that might be sitting on juries one day. I want to know if you think 5 hours is a long time to sit there and deliberate or not long at all. Then the judge asks now, do you want the jury polled? And he says, I guess so. And the reason you have the jury polled is to make sure each one of them has this conviction and made this their verdict and this was their vote and nobody pressured them into doing it, because now is the time they can come out and say, I actually didn't feel this way, I actually didn't vote this way. And it has a lot of appellate issues to do too. So you could say each jury found him guilty. And now we get to hear that.
Clerk could please poll the jury.
Yes, Judge. Mr. Luis Daly Rosado.
Your Honor, before we go through that, can we approach you real quick?
Yes, come on up. Okay, please poll the jury.
Yes, Judge. Mr. Luis Daly Rosado. Is this your true and correct verdict? Yes. Mr. Mark Douglas. Is this your true and correct verdict?
Yes.
Mr. Russell Cromley. Is this your true and correct verdict?
Yes.
Mr. Harold Waters. Is this your true and correct verdict?
Yes.
Mr. Matthew Ebert. Is this your true and correct verdict?
Yes.
Mr. Jeffrey Parker. Is this your true and correct verdict?
Yes.
Ms. Nicole Stillwell. Is this your true and correct verdict?
Yes.
Mr. Edward Storr. Is this your true and correct verdict?
Yes.
Mr. Artemio Martin III. Is this your true and correct verdict?
Yes.
Mr. David Van Hout. Is this your true and correct verdict?
Yes.
Ms. Christy Wimmer. Is this your true and correct verdict?
Yes.
And Ms. Charlene Louise Charles. Is this your true and correct verdict?
Yes.
All right, very good. Thank you, members of the jury. So now that you have found the defendant guilty of first-degree murder, that means we will be going into a penalty phase. However, I'm going to give you guys the day off tomorrow. All right? There's some things we need to do as far as to get ready for that phase of the trial, which will begin Wednesday at 9 a.m.
All right, so let's pause it. She said a lot right there. The judge said, thank you for your service. Now that you found him guilty, we're going to give you the day off tomorrow, which is today. So they're not doing anything as far as the jury today. And tomorrow on Wednesday, we start the penalty phase. So make sure you get in the comments with the big eye emojis if you want us to do a video on that penalty phase, okay? Because that's still to come. That's going to start on Wednesday. We don't know how long it's going to go. We don't know what exactly they're going to do during that. Hopefully we get Big George in here to talk to him about it. I think it's interesting now what the judge says next, because this is something that a lot of people talked about. Should this have been a change of venue? Should they have sequestered the jury? No, because they have other rules in place to try to protect that in cases like this. And you're going to hear some of them. The judge says, don't go on social media. Don't look up stuff about this case. Don't watch the Lawyer You Know's YouTube videos. She doesn't actually say that, although it'd be kind of cool. So yeah, they're saying don't do some kind of alternate investigation to bring other facts into this case that you didn't hear in the courtroom. Consider yourself still part of this jury, still not paying attention to what's going on. Don't talk to your friends or family or anybody about it. You're still under those rules. Let's listen to the judge explain it.
I anticipate that we will be concluded by the end of this week, so you don't need to worry about that, but I'm going to give you guys the day off tomorrow.
There's her answer. She expects it to be done by the end of this week. Let's see if she's right.
All right? So you can go tend to your personal affairs, do what you need to do, and then we'll see you back here Wednesday at 9 a.m. Since you are still serving as a juror in this case, however, the rules still apply. You can't talk to anyone about this case. You can't do any research about this case. You can't watch, listen to, read any news accounts related to this case. And that will be the rule until I discharge you completely as a juror. All right? So with that, I think the pizza did arrive, so I don't know if you want to grab a slice on your way out the door, but there is pizza back there. And we will see you all on Wednesday morning at 9 a.m. All right? Thank you.
So that's interesting. I'll just pause there because this is something lawyers talk about while juries are deliberating. They ordered pizza, so they ordered dinner. So my guess is the lawyers thought they were going to at least stay and eat dinner before they come up with their verdict. And they didn't in this case. As the judge mentioned, the pizza arrived. If you want to grab a piece on your way out, go for it. But usually the jury will wait, eat the dinner, deliberate a little bit longer, talk more about this case, and they didn't, which means they were sure about their verdict. And I'll just let the cat out of the bag. I don't think 5 hours is very long when a man's life is on the line and it's a double murder plus aggravated battery, first-degree murder, attempted first-degree murder. There's 7 charges. I mean, just to read through the 7 charges, look at any evidence takes you some time. And again, they didn't even stay for dinner, which to the lawyers is a thing. That's something we would be talking about as lawyers, that they didn't even stay for dinner.
All right.
He stands again as the jury leaves. So that's something we do in trials, is we stand, usually unless the judge doesn't allow us to, which happened in our last trial, but we stand as the jury enters, we stand as the jury leaves as the lawyers. The client's supposed to too. We have had some criminal defense clients that refuse to stand when the judge enters, when the jury enters, right? Some of them can be disrespectful. I've seen other trials where they're a little bit disrespectful about it. They won't stand, they refuse to stand, things like that. He just was convicted on all 7 counts, guilty across the board, and he still stands up out of respect for the jury when they leave the courtroom. I mean, some people may say they still have a decision to make in his case, so his fate still lies in their hands, but I mean, this just kind of goes along the line of how he's acted professionally throughout the entire trial, for the most part.
Okay, everyone, have a seat. So, Mr. O'Neal, now that you have been found guilty of first-degree murder, we now go into penalty phase. And as you are aware, it gets no more serious for any defendant in any criminal courtroom in this country than what you are facing now. I respect the fact that you chose to represent yourself, and I have to tell you, I think in another lifetime, you would have been an excellent lawyer. I really think that. You speak with great passion. I understood exactly the points you were making. I knew what you were attempting to get across in your opening statement, your cross-examination of the state witnesses, the direct examination of your witnesses, and your closing argument.
A big compliment from the judge, which is kind of what we've been saying the whole trial, is he, in another life, he would have been a great lawyer. Similar things were said to Ted Bundy. It's not exactly the group I want to be in, but I mean, he did do a good job. He smiled there. It looked like he appreciated it. I mean, he knew he was up against the wall here, and I do think he did the best that he could. And I mean, he smiled. He looks just like a normal person. I mean, he's just sitting there. It's weird to think that this guy is a menace to society and convicted of all these heinous crimes and potentially going to get the death penalty. And we're just looking at him having this nice, normal conversation with the judge at this point. But the judge does say, this is the most serious part of any trial, of anything you can be in Florida, which is the death penalty phase that we're starting.
Ultimately, your arguments were not persuasive to the jury, but nonetheless, I was able to follow exactly what you were trying to accomplish. However, as we move into penalty phase, I'm really going to strongly encourage you to consider allowing counsel to now step in and represent you. This is a much more specialized and rare area of the law that very few practitioners really practice in.
And she's right. And this is something that we're talking about, which is why we need the emojis in the comments, the big eye emojis, because I've never done this. I've never done a death penalty phase before. So if we want to get some real experience in the room to talk about that, we're going to need Big George here for that. So we'll see if we do that later this week. But for him to try to do this on his own is even a step further than trying to try the case on his own, because lots of lawyers have tried cases. Less have tried double murder cases, but still a lot of lawyers have tried double murder cases. But very few have done this actual death penalty phase of a trial. So she's really trying to caution him, please let your counsel step in now and handle this.
As far as truly understanding the aggravating factors the state has to establish, and now you would have a burden of proof with regards to the mitigators, whether they're statutory or non-statutory. You've got to come up with proof by greater weight of the evidence that the mitigators actually apply. And you would have to come up with not just applicable statutory mitigators, but any applicable non-statutory mitigators. And I'm quite confident that your standby counsel would have a much better grasp on what those potential non-statutory mitigators would be. So I want you just to think about it overnight. I don't want you to make a decision right now. I want you to give it some serious consideration.
So she goes through using all these big legal terms like mitigating factors and statutory mitigating factors and explains to him that she really thinks his standby counsel would do a better job because this is a very technical argument and this is much harder than just arguing facts and arguing guilty or not guilty, innocent or guilty, whatever it may be. This is much different, much more technical, much more difficult, different standards apply, different statutes apply, and it's much harder to grasp this as a layperson. So she's really pushing forward, and very importantly, she's putting all of this on the record, so he, again, can't say that this wasn't explained to him, that he didn't have the opportunity to understand how hard this was going to be for him to represent himself pro se, and that he should have been warned and he should have been told to get a lawyer. All this is on the record. She's even saying, sleep on it tonight, don't make a decision right now, and come back tomorrow, and we'll hear if you've decided to bring in counsel for this portion.
All right? And we're going to reconvene at 10 o'clock tomorrow morning, and we'll discuss it further, and you can tell me then. But I really, really want to strongly advise you to go ahead and let counsel represent you in the penalty phase because the consequences are so serious. Okay?
Yes, ma'am.
Okay. Very good. That's all I asked. Just think about it. All right? All right. See you all at 10 a.m. tomorrow. Okay? Very good.
And that's where we'll end it. So she says, okay, and he says, yes, ma'am. Again, polite and professional. It's really sad. It's really, really sad to look at this guy and think of what he could have been. I mean, it's really sad. So the last thing I just want to mention is we did actually go into the alternate jury pool here. They picked 2 alternates, and one of the jurors for medical reasons, had to step out of the trial, which is why we pick alternate jurors. So one stepped in there, and they didn't have to send 2 jurors home at the end of the trial. They only had to send one, who was probably bummed they didn't get to partake in the deliberations and the calling of the verdict, or maybe they were happy to just get out of a crazy case like this and not have to do it. But that is why we pick alternate jurors. That's why if you ever think you're an alternate juror, if you get picked for a jury, pay attention, because you never know when you're going to get tagged in, and you better know what's going on and listen to the evidence and weigh it, because it is so serious, and we want you to pay attention, and we want you to be involved, and we want you to be ready to give your vote on what you think the verdict can be, whether or not you think you're an alternate juror, because at any moment that can change, especially in a post-COVID world. So for the last part of the video, I just want to touch on potential appellate issue. If Ronnie O'Neal is going to win an appeal in this case, right, before the penalty phase, because that'll be different. He can appeal the sentence or the penalty kind of for different reasons. But for now, just talking about appealing this verdict and things that happen in this trial, I think his best bet is a cumulative effect type of an appeal, okay? So that means a ton of little errors were made that were so insurmountable that he didn't get a fair trial. We talked a little bit about this in the Derek Chauvin trial, but I think Ronnie has a better chance at it because there were some times here and there where the state asked questions that they should have known were inadmissible, like to elicit hearsay or to go way too far down the emotional track to try to pull sympathy and empathy from the jurors for these heinous crimes and the minor victims in this case. I think that certain testimony from the law enforcement officers talking about how they made an arrest for murder. I think law enforcement officers know that you can't necessarily testify to some of that stuff, and they still said it on direct and cross-examination. I think calling him Little Ronnie throughout the closing argument is also objectionable and something that's tugging at the heartstrings of the jury. I think that Ronnie O'Neal himself, or potentially a lawyer, can go through this trial and pick apart certain things that the state did that may have been unfair or may have been inadmissible, but because he represented himself, he didn't object to those, he didn't know how to keep those out of evidence, and they just became an insurmountable mountain that he could not climb to get a fair trial in this case. Now, will he win on that? No. It's very unlikely that you win on a cumulative effect. I just think that's personally his best chance. I don't think he's got a lot of options. He doesn't have an ineffective assistance of counsel claim, which is one that just about every criminal defendant that loses a murder trial, they're going to file it no matter how good of a job their lawyer did. So I don't think Ronnie's got a lot of options, which is why I picked that cumulative effect one as what I think would be his best option to try to pick apart the state steamrolling him and doing things they knew they shouldn't have done. I really think the state did do a good job, so I don't think there's going to be enough there for an appeal. Let me know if you guys see any appellate issues. Let me know what you think potentially could be an appellate issue. And don't say ineffective assistance of counsel, and don't say he should have taken the stand, because those are not things that he can say, I need to appeal or I need another trial because of those. He knowingly waived those rights. The judge did colloquies, kind of like we heard some of today. I bet you there were tons of those types of colloquies where the judge warned him against doing this, warned him against not taking the stand, warned him against representing himself, and he made those decisions. He invoked those rights and therefore waived his right to appeal certain issues. So let me know what you guys think. Don't forget to leave those big eye emojis in the comments if you want to talk more about the penalty phase. Let me know the questions you have, and we'll continue doing this thing. So thanks for being with us today.
Thanks for watching this episode of The Lawyer You Know. If you like this content, please share it with your friends. Make sure you subscribe to our page and like our videos. If you want some interaction, get in the comments and we'll be sure to get back to you. If you want to know any more information about our firm or this page, you can find out in the description or visit tragoslaw.com. We post multiple times throughout the week, so make sure you hit that bell so you can get the notification and not miss out on the next episode.